Article 21 is one that has seen a lot of history since 1950. It says a person's life and personal liberty can be deprived provided procedure established by law is followed. Now, life is everything. Personal liberty within that is the soul of it. You can still have it deprived. You know, for example, someone has been a terrorist, he's murdered, gang raped, part of it. All these are serious crimes, and they may end up in personal liberty being violated, for example, jail, or in fact life itself may be taken away, death sentence. That is, a death sentence. So, life term or death sentence. Possible, provided procedure established by law is followed. Now, so that's verbatim, Article 21. In 1950, a famous case, landmark one, was A.K. Gopalan. A.K. Gopalan was a legendary communist leader. He was arrested on a preventive basis. Government thought, the police officer thought that he would commit crimes against the security of the country, and therefore, even before they had substantial evidence, they imprisoned him. And that went to the Supreme Court. He obviously moved the Supreme Court under Article 32. Sir, my right to life and personal liberty have been deprived, have been taken away. Render me justice. Supreme Court called the police. Police said, sir, this is the Preventive Detention Act, and this act we have followed every little bit of it, and therefore, sir, we have done all that it is necessary for us to put him in prison on a preventive basis. Supreme Court said, that's fine, you've done what you are expected to, compliance, and so procedure established by law following the preventive detention law has been complied with, and therefore the detention, the jailing is legal. That was in 1950. But by 1978, the tables have turned on the interpretation. It's a complete 180-degree change. That is called the Maneka Gandhi case. You know, her passport was impounded. She wasn't given a chance to speak. She wasn't told it was being impounded, and she wasn't given an opportunity to defend her actions. It was impounded without any opportunity being given to her. So she goes to the Supreme Court. Sir, traveling abroad, Article 21, liberty includes traveling abroad and coming back. Here I am, sir. My passport has been impounded. And the Honorable Supreme Court imported the American Doctrine of Due Process of Law, which is contained in 5th and 14th Amendment Acts in America. What does due process of law say? You know, in the due process of law, you look into the law itself and see, is the law fair? Is the procedure fair? Reasonable? Is it defensible? Is the law itself fair? What does it take for the procedure to be fair, reasonable, and maintainable? You know, you want to punish somebody, cancel a license, impound a passport, put him in prison. All these are fairly punitive actions. And you want to punish somebody, you are a civil servant tomorrow. God forbid if some civil servant has to be dismissed, if he had to be demoted, and so on. You know, a full spectrum of rights implicit in what is called natural justice have to be respected. You know, justice is built into nature. Law is only recognizing it. If it doesn't recognize, then the justice is not maintainable, is not to be upheld. So what does it take? It takes, number one, tell the reasons for detention. 2, give opportunity for self-defense. 3, give opportunity for having legal help. 4, let there be nobody in the jury who has an interest in the case. And let the law not be vague at all. All these reasons, all these elements of natural justice are due process as far as the procedure is concerned. So was Maneka Gandhi given the opportunity to put down her side of the case? No. So natural justice, which is another term for procedural due process, has been violated. What is the substantive due process? Substantive due process is whether the law itself is fair and reasonable or is it arbitrary. So you look into the law. I'll give you an example. Take the Aadhaar Act. It says your biometric details can be taken by the government. Then it goes to the Supreme Court. And then the Puttaswamy case verdict emerges, in which the Supreme Court said, okay, the government is doing quite a lot of welfare, so it is entitled to take your biometric details for authentication and deduplication, but not for everything that the government does. It can ask you for your fingerprint, which means there is a right to privacy. That includes holding back your biometric details unless reasonable restrictions are, unless the restrictions are reasonable. So that is substantive law, substantive due process of law. Due process. What is the due? Procedurally, natural justice. Substantively, the law has to conform to the human aspiration, the constitutional values. For example, right to privacy, which is the most sacred, most essential part of human life. If that can't be given constitutional recognition, put on a pedestal as a fundamental right, made a part of Article 21, what other right precedes it? It's on par with every other fundamental right, which is a core fundamental right. Article 14, 19, 21, and so on. So the Supreme Court in 1978 had come from Gopalan, which is the procedure established by law, to the due process. Due process, procedural as well as substantive. And since then, in the recent years, we have had so many cases where due process has been applied and significant justice has been rendered. For example, I've already told you about the Aadhaar Act and the birth of a new fundamental right called the right to privacy in the Puttaswamy case in 2017. And right to privacy being read into Article 21, the right to life and personal liberty. Then you come to the common cause case 2018. You know, you had read Aruna Shanbag case 2011. The lady was molested. She lost her consciousness. She was vegetating. The nurse friends of hers in the KEM hospital of Mumbai were very proud to be serving her, but her life was miserable. She was not talking, let alone talking. She was biologically alive, but nothing more. And so the case goes to Supreme Court. Supreme Court says, let her die, withdraw the medicines, allow her to die, a death in dignity, death being a part of life. In other words, you have the right to live in dignity, which also includes at the end of life, die in dignity. That is, let there be passive euthanasia. That was Aruna Shanbag 2011. That advances to common cause in 2018, wherein it is said that everyone, while he is fine and in good health, can write out a living will, that at any point of time in his own life, if he becomes unconscious, if his diseases are so pathologically painful, and if he becomes a financial burden on anyone, while he can think freely, he can write out a advance medical notice, will, saying that, don't put me on ventilator perpetually, and so on and so forth. That is called a living will. Living will is very crucial for death in dignity. And so Common Cause verdict of 2018 adds a new right to Article 21, wherein it is said that the right to die with dignity is a part of right to life. You know, we have always known that right is not merely biological. It is the right to life is not merely biological. It is more than biological. It is life with dignity, with a string of rights attached to it. You know, Article 21 has bred a family of related rights which are a part of life. So that is Common Cause. Then you go back to ADR case 2024, where it relates to electoral bonds. You know, electoral bonds are very peculiar. There you had bonds, you had earlier also donations, but the donations mandated that you reveal the name, and that is a part of the public information. But the people who donate, they said, sir, we don't want to donate. We want to donate only to one or two parties, not to every party. If our name is associated with a donation for a particular party, then others will also come after us and we may be subjected to harassment and so on. Therefore, sir, hold back the information. Nobody should know who we have donated to, how much we have donated to. That should be in absolute secrecy. It's not, that is right to privacy. But under Article 19, 1A, for me to cast my vote, I need to know about the party and the candidate. So right to information, which emerged from right to freedom of speech and expression, requires that I know about the political parties. So my right to know and the donor's right to privacy are clashing, and neither can be sacrificed at the altar of the other. Double proportionality. And based on this, the Supreme Court said, why are you keeping back all the information? Is it necessary at all? Doctrine of proportionality demands that you don't restrict more than necessary. So we have alternatives. Electoral trust is there. That's a transparent fund maintained by a corporate or another NGO. Into that you pool your money and based on certain objective criteria, donate to political parties. That is the electoral trust. And there are so many other alternatives. Based on that, the Supreme Court said that the electoral bonds completely violate the right to information and give right to privacy perverse importance. And therefore, we are striking down. That is the ADR case, wherein the substantive due process of law has been applied and the law itself being unfair and unreasonable has been struck down. The electoral bonds don't exist anymore. The entire law has been nullified. And then I'll take you to another procedural due process, bulldozer justice. You know, somebody is in illegal occupation and you need to demolish it. But whether it is illegal occupation or not, it is not your suspicion or hearsay that matters. You know, after all, you are demolishing his abode, the place where he lives. Give him all the opportunity to defend himself. In case he cannot, go right ahead and demolish it. So for that, tell him, show him the cause as to why his house can't be demolished. Give him the reasons. Allow him legal assistance. Hire a lawyer. And also give him an adequate time. And let nobody, on the basis of whatever, sit in the jury with a personal interest in the case. All these are the elements of natural justice. We already have discussed it. And all of them have to be respected. Otherwise, it is bulldozer justice. And the Supreme Court came down very hard on that in 2024. So all these recent developments in constitutional law go to show that the Honorable Supreme Court is interested in ensuring that not only is the procedure fair, it is not enough that you follow the procedure. Not only is the procedure fair, just and reasonable, also the substance of the law also has to conform to basic constitutional values. These are the recent constitutional case law examples. Now let's turn to the slides, infographics, and see the entire thing one more time, a revision for you. And if you have further doubts, that should also be clarified. Let's see it. So Article 21, no person. The person can be you or I, it can be an animal, etc. It can even be a forest or a river or a mountain or a hill. That's another debate. Personal liberty. Don't just say liberty. Say personal liberty. The person who gets one more mark will say personal liberty. You know, this procedure established by law has a curious history. You know this, that Indian Constituent Assembly 46 to 49 borrowed from so many global constitutions in order to enrich our constitution to the hilt. And in the process, what did they do? You know, America, Britain, Canada, Australia, Germany, South Africa, whatnot. And from Japan, we borrowed the procedure established by law. Japan did not borrow it from Britain. Japan, the making of the Japanese constitution post-World War II was guided by America. And American suggestions went towards telling Japan, you know, you incorporate the procedure established by law. In fact, if you read the commentaries on the Constituent Assembly and Article 21, you will find out that Indian Constituent Assembly discussed whether we borrow from America due process or we stick to procedure established by law from Japan. They said that, you know, ours is a parliamentary democracy. In our parliamentary democracy, it is the parliament that prevails, though it is not sovereign, it prevails. And let the judiciary not be given undefined power, which goes with the expression due process of law. And so, let us not have the due process of law. Let us have procedure established by law. Parliament establishes the procedure. Executive, makes some orders. Based on that, action is taken. That is enough. Due process means judicial supremacy. That is why some people say Maneka Gandhi case, and since then Indian judiciary, the Honorable Supreme Court, has been quote-unquote overreaching. When the Constituent Assembly did not give you the right to apply the due process doctrine, how did you assume it? How did you assert your power to take over this doctrine called the due process? That's a debate. It can go on. But it's the inherent right of the judiciary, being a court of record, that it protects you and I. And in the process, it can expand its role so that the rights that we enjoy are expanded. You have seen how many rights have come out of Article 21, thanks to due process since Maneka Gandhi. What it originally meant, we have seen, procedure, follow the law, your actions are right. But the court wasn't looking into whether the law itself is fair and reasonable. But from Maneka Gandhi, this is the procedure established by law, this is the due process, this is the comparison. Article 21 requires fairness. Fairness. In other words, not just the procedure I told you. Procedure is one part, substance is another part. For example, the right to privacy came out in the Puttaswamy case not as a matter of examination of the procedure, but because the Honorable Supreme Court felt compelled to discover a new right. That is why, the Supreme Court also says that there is so much to be unearthed. The doctrine of dark matter. You know, you can't see it, but it is there. So in your judicial review, you unearth it, you discover it. So many rights are discovered. I've already told you some rights, the right to privacy, the right to dignity in death, and so on and so forth. Not just procedure, you need to have an entire law that is fair. And this is the due process. And if you can, this is Gopalan, A.K. Gopalan, the communist leader. And then this is Maneka. This is 50, procedure. This is due process, Maneka. You know, in your answers, if you get an opportunity, if you drop the line that 14, 19 and 21 are to be read together. What did the Honorable Supreme Court say in the Maneka Gandhi case? You said reasonable in Article 19. Restrictions have to be reasonable. Why have you not used the same word reasonable in 21? You just said procedure established by law. since we read 14, 19 and 21 together, this is the golden triangle, same reasonableness. After all, under Article 14, rule of law, if an application is arbitrary, it is struck down. Classification has to be reasonable. 19, reasonable restrictions. Why not the same word reasonable be also incorporated into Article 21 when you talk about the procedure as well as the substance of the law? And therefore, golden triangle demands that every action is reviewed for reasonableness, justness and fairness. That is how golden triangle concept is very important. Who knows, maybe it will come the day after in your general studies exam. So Puttaswamy, ADR, common cause, bulldozer. These are the 4 recent examples where the substantive and procedural due process has been applied. That is the lecture on the due process versus the procedure established by law. You will find the entire history with conceptual clarity and all the necessary details here in the book. Please go through.